Good afternoon. We're here at Taylor English Duma for Quillian's Kernels. The subject matter this afternoon is summary judgment motions. And to refresh those people out in the world that hear this or see this videotape, please remember that we are not providing legal advice here at Taylor English. This is a training tape. It's to give you things to think about in the course of your litigation, but please consult your lawyer. And if you are a lawyer, consult the rules. For those that y'all don't recall, that when I say, when in doubt, you say, read the rules. That's true of the people out there in internet land who are watching this. As I said, today we are covering summary judgment motions. This will probably be a two-part series. The first thing will be the basic uses of summary judgment. When summary judgment, what type of circumstances summary judgment is appropriate, and what you have to do in order to get summary judgment. We'll be focusing principally on the plaintiff's side, but if we get to it, I'll have a hypothetical which stretches our minds with respect to things that can be and must be done in order to obtain summary judgment. So, what rule is summary judgment under the Civil Practice Act?
9/11/56.
9/11/56. What are the goals of summary judgment? What's the purpose of it?
Knock out claims. To win on claims without having to go to the jury.
To remove issues that are not in factual dispute.
Okay, so we've got to eliminate claims prior to the time the trial is to be had, either by winning on them from the plaintiff's side or from the defense side. They're to potentially to whittle down the facts that are in dispute, which can make a trial shorter. So a trial can be reduced by both winning claims and or eliminating them, depending on which side you're looking at it from. And also, the trial can be made shorter if facts that are not in dispute are brought to light. Is there a practical use for summary judgment unrelated to winning anything?
Settlement.
Yes, it could put the case in the mode of settlement. For instance, somebody may move for summary judgment in order to make the other side think seriously about the weakness or strengths of their case, even if they think it's not a real high likelihood that summary judgment will be won by the party making the motion. Tends to bring people to the table and make them think seriously about their claims. When would you typically bring a motion for summary judgment?
At the close of discovery.
At the close, after discovery is over, is a time that's often thought of as the correct time for summary judgment. When can one bring a motion for summary judgment if you're the plaintiff?
Within 45 days after service.
When in doubt,
Check the rules.
read the rules. Okay. 9/11/56A. I'll take out a couple of words here. A party seeking to recover upon a claim may, at any time after the expiration of 30 days from commencement of the action or after service of a motion for summary judgment by an adverse party, move with or without supporting affidavits for summary judgment in his favor upon all or part thereof. So if you're the plaintiff, or if you're somebody that has asserted a claim against somebody else, then you have to wait a bit before you can move for summary judgment unless somebody moves for summary judgment against you. Now, what if you're the defendant on a claim, the responding party? When can a defendant move for summary judgment?
Anytime.
Anytime. After the commencement of the action, obviously, right? So, for instance, if you're a defendant, you could get served on Wednesday, and on Thursday, if you got a crackerjack lawyer, move for summary judgment. I, in fact, have one case that I moved to dismiss it, basically, but it was more or less like a summary judgment motion. The day after it was served on my client, and we had a hearing that same day that I moved, and we won. Judgment was granted in our favor. one of the happiest days of my client's life. My fees were cut very short because of that early success. But in fact, what happened there is the court held an evidentiary hearing and granted it on the cross-examination and everything. It was in a commercial real estate case too. Okay, so
Between the motion to dismiss and motion for summary judgment.
what is the difference between a motion to dismiss and a motion for summary judgment?
Motion for summary judgment includes evidence outside the pleadings,
Okay.
outside the complaint,
What are the pleadings?
the answer in the complaint.
And any document attached to the complaint or referenced in the complaint.
Okay, so,
As long as it's central to the claim and not in dispute.
so we would have the complaint, the documents attached to the complaint,
Or
which
reference.
are not in dispute, such as the defendant admits that the contract copy of the contract is attached. Or, and this is an interesting one, I don't know the exact resolution. I had a defendant attach something to the answer, say that attachments to the pleadings were permissible for use in a motion to dismiss, and move to dismiss. And I see some nods here. Have you ever had that happen?
Yes,
It happened to be that document that was attached was a non-controversial document. But it seems odd to me the defendant could attach something to the answer, which does not have to be responded to by the plaintiff, and then move to dismiss on the basis of that document.
Just as a nomenclature thing, I'd probably call that a motion for judgment on the pleadings.
It doesn't happen that much in federal court because typically you file the motion to dismiss to avoid filing the answer. But in state court, where you've got to file the answer anyway, it comes up more often. I think the idea is that if you've got a document that's central to the case and it's undisputed, you can consider the claims based on the pleadings and the documents and dispose of it. One issue we just kind of went through that I'd like to back up on, and I'm not sure I know the answer. Can you move for summary judgment on an issue or element of a claim, or only on claims or defenses?
Well, when in doubt, read the rules. 91156D, the question is, if you didn't hear that, do you have to move for summary judgment on an entire claim, or can you move for summary judgment as to a specific element of a claim?
Correct. It may be one and the same if the plaintiff has to prove all 5 elements, the defendant only has to show one. But there can be situations where winning on one element still leaves the claim alive, but you've eliminated that element. And can you do that on summary judgment?
Okay. We were going to get to this, but the question is, which effectively is, can facts and/or the application of facts to law be applied by the trial court as a result of summary judgment, even though the entire claim is not eliminated? Is that basically?
Not exactly. I was assuming, again, if you're using the same standard, no genuine issue of material fact, but you just want to eliminate one aspect of the claim, but you're not moving for summary judgment on the entire claim.
Okay. Well, it depends on whether that is. Certainly you could eliminate certain types of damages that would be part of a claim on summary judgment. But we'll get to this more deeply, but Rule 91156D talks about case not fully adjudicated on the motion, and it has a provision that it basically says the trial judge can, upon a failed motion for summary judgment, one that does not result in the conclusion of the case or the elimination of the claim. I think you probably want to be able to do that as part of a motion for summary judgment, but as a result of such a motion, the judge can thereupon make an order specifying the facts that appear without substantial controversy, including the extent to which the amount of damages or other relief is not in controversy, and direct such proceedings in the action as are just. Upon trial of the action, the facts so specified shall be deemed established, and the trial shall be conducted accordingly. So the trial court can certainly take a motion for summary judgment and whittle down the case whether that means it's appropriate to just try to knock out one element of a cause of action or a claim without all the others. I think that would be certainly true as to types of damages, but I don't know about any other, whether if you can't get rid of liability at all and and you're just trying to get a ruling on one thing, I think you can try it. Court would probably be, if it's gonna eliminate a lot of trial, the court would probably be happy about that, but I'm not sure if it's contemplated directly in the wording of the rules. Okay, so let's assume you are a defendant, let's assume you are a plaintiff, and you file your lawsuit, serve it, and the next day a motion for summary judgment comes back to you, but you need to get information or evidence from the defendant in order to prove your case that you believe that the defendant has, but that you don't have in your possession. Is there any remedy, or do you just have to respond to the motion for summary judgment and pray the court denies it?
56F.
Okay, under 911-56F, which we did cover fairly thoroughly in a previous Quillian's kernels, you can move the court setting forth what you believe you will find in discovery if you pursue discovery and seek additional time to respond to the motion for summary judgment. And I believe the court, my experience of courts have pretty readily granted those motions, at least with respect to specific discovery, so that they don't unnecessarily prejudice a plaintiff who needs to get the information from the defendant. Is everybody sort of in agreement with that's the way that often works out, at least for a limited period of time?
And isn't it 56D in federal court?
We're covering the state and superior courts. Is it Rule 56D in federal, under the federal rules?
I thought it was F.
I think it's F under both.
We can check that, Henry.
But we will check it out. Read the rules. There is a, let's see, that we have talked about all these things you need to do in discovery in order to get to the point where you can move for summary judgment. And so, can we agree that what we've tried to accomplish during discovery is to collect some sort of facts that would be sufficient for moving for summary judgment, that then can be used, if you're the plaintiff, to establish the entirety of your claim?
I have been vindicated. 56G in federal court.
Not unlike Candy Crowley, we have an immediate fact checker who apparently says that Rule 56D under the Federal Rules of Civil Procedure is roughly the same as 56F under the Georgia Civil Practice Act. Is that what we're saying?
Yes, that is what we are saying.
Okay. By the way, I did have a case like that where I moved for summary judgment. The plaintiffs moved under Rule 56F for additional time to get discovery, and it took 4 years thereafter for the judge to rule on summary judgment, and it all ended up being exactly what the complaint contended it was. So, as I said, sometimes judges are overly welcoming to people who are trying to get relief under Rule 56F. Okay, so let me give you a hypothetical, and we'll talk about motions for summary judgment in the real world. A debtor executes 2 notes to 2 different creditors. One note is less than $3,000 and charges usurious interest. The other note charges usurious interest, but can be made legal if the plaintiff creditor can show that the note is secured by a first priority security deed on real property. During the course of the years that these notes are in place, the debtor pays to a single person in a single check the payments that are coming due on both notes, and that single person allocates the money to the notes in accordance with their terms. In other words, on the $3,000 note, is in accordance with the usurious terms of the $3,000 note. And on the other note, it's in accordance with the terms of that note, which will not be usurious if the creditor ultimately can prove a first priority security interest in real property. Okay. Undoubtedly, the debtor defaults, and the plaintiff, the creditors bring a joint lawsuit for recovery on their notes against the debtor. What must the creditor do in order to move for summary judgment to get the maximum recoverable amount on their claims against the debtor? All right. What is the fundamental necessary thing that must be established under Rule 91156 for a plaintiff to obtain summary judgment against a defendant?
It's got to show his proof of facie case. It's got to show the notes were executed. I mean, that's the first step.
Okay, well, that's breaking it down. Overall, what must a plaintiff show in order to get summary judgment against a defendant on pending claims?
That they're entitled to relief under the law based on the undisputed material facts.
Yes, which is the same way as saying there are no genuine issues of material fact in dispute. So there's two adjectives in that Rule 56C standard, right? A dispute would have to be genuine as opposed to being fanciful or in the hallucinatory mind of the defendant, for instance. For instance, if the defendant claimed he made all these payments that there was no evidence of, the court could find that the defendant, even though he may testify that he made all these payments, if he can't show any checks or anything else, that might not be a genuine issue, even though there's testimony to that effect. Unless he can provide a really good explanation for why the money never came out of his checking account that he was supposedly making the payments out of. And then the facts that cannot be in dispute have to be material facts. We're not talking about a situation where there's some collateral fact that has nothing to do with whether whether the plaintiff creditor is entitled to judgment. If they're disputing over one thing, but it has nothing to do with the suit on the notes, those aren't material facts. Summary judgment could be entered. However, in this hypothetical, we've got some other squirrely things going forward. If the creditor is to get a judgment for a money judgment against if the creditors are to get a money judgment or money judgments against the debtor, what also do they have to show in order to get that judgment, other than purely liability? Excuse me?
The amount itself.
The amount of damages, which we've got a somewhat complex factual circumstance with respect to the damages. So let's say, for instance, the creditors move for summary judgment, and they establish, as Mr. Boyle has pointed out, that the debtor executed the notes, that he got the money, face value of the notes, and that he made certain payments over time, and then he went into default and by not paying the notes, which recall were made by a single payment to a single person who then allocated the payments to the two separate notes held by two separate creditors. Is that enough for the plaintiff creditors to obtain summary judgment against this debtor?
The notes are usurious on their face, so the debtor raises that as a defense, and that becomes an issue of dispute.
Okay, so if the debtor raises usury as a defense, that causes all sorts of havoc as to whether a judgment could be entered based on the mere presentation of the facts that we discussed. What would be necessary in order for the plaintiff creditors to respond to a defense that usury was in play with respect to these notes?
Well, one creditor needs to show that it's secured by real property. So if they could show that the debt was secured by real property, then it eliminates that argument.
Okay? I said a first priority security interest. So in that instance, let's say the creditor with the note that can become non-usurious by reason of the fact that the note is secured by a first priority security interest must, one, somehow introduce evidence that would be admissible at court that the note is secured by a security deed that's in the state of Georgia. What does the creditor have to do in order to show that on summary judgment?
Probably an affidavit, not only with the security deed, but also title search.
Okay, so there would be at least two elements of that, right? You'd have to prove that the security deed was there, probably that it was recorded, that it was executed by the debtor defendant, and that utilizing title searcher or an admission from the defendant that it was actually a first priority security deed, right? So that's a fundamental principle of summary judgment. The person moving for summary judgment has to use affidavits and other evidence obtained during discovery or from their own personal knowledge to establish the facts in a manner that would be admissible at trial so as to get the facts established for summary judgment. Yes, ma'am.
I was just going to say, how would you raise a defense if you think that part of the evidence submitted in support of the other party's summary judgment motion would be inadmissible at trial?
Okay, so let's assume, and I think that's a perfect question. Let's assume that creditor that holds the note that would become non-usurious if secured by a first priority security interest submits a security deed which with an affidavit that says, I was present when the defendant executed this security deed. I saw the defendant debtors put his signature on the security deed. I took the security deed and I filed it of record. And I know it's first priority. All right, so, but let's say the defendant debtor knows that he actually had another mortgage on the property at the time that he executed the security deed. What does the defendant debtor do to knock out the first priority assertion? Well, first of all, you would state that in your response to the motion for summary judgment. I was actually thinking about this earlier and seeing what, there are various ways. I think definitely you argue it. The problem is, I'm concerned that if you only argue in a response brief for a motion for summary judgment, it might not adequately bring that admissibility issue to the attention of the court. So, Foy, what would you do?
You gotta have an affidavit, and the copy of the prior existing mortgage.
Okay, so Foy would affirmatively come forward with affirmative evidence submitted by the defendant to knock out the unsupported statement of the creditor saying, I know it's first priority, without giving any background. That would be the safest thing to do. Now, the other thing you could do as the defendant, which is less reliable, is just argue they didn't prove up the fact that it was first priority, because if in the absence of proving it's first priority, the note would become usurious and the way the payments were applied would be completely different. Yes?
Shouldn't you also file a motion to strike the affidavit?
And that's what I was getting to when I was saying I'm not sure, and that's a great point. I'm not sure it would be adequately brought to the attention of the court by merely putting it in a brief in response to summary judgment, because how many of y'all have ever had a judge that you stood up before and said, Your Honor, we're here on summary judgment. This is a case that is very ripe for summary judgment, and let's say it's a suit on notes, and the judge says, oh, that's the car wreck case, right? Sometimes they don't read the motions before you show up to argue them, so you need to have something blatant on the record, like I think it's certainly appropriate to make a motion to strike saying as to the issue of whether or not the security deed is a first priority deed, there's been inadequate showing of that.
Caveat in federal court where there are page limits on briefs. There are federal judges, there are plenty of holdings out there that say there is no such thing as a motion to strike. Show me in the federal rules of civil procedure where there's any mention of a motion to strike, and filing a motion to strike is simply a backdoor way of increasing the pages that you're submitting in your summary judgment briefs. And there's a judge in the District of Minnesota who has that in his standing rules. There's no such thing as a motion to strike, and if you file a motion to strike, it's going to be sanctionable, because the way that judge reasons, as does a number of other judges, if you've got 25 pages for your summary judgment brief, you've got to deal with that affidavit in the 25 pages or seek an extension of the page limit. You can't get around it by filing a motion to strike, which is nowhere mentioned in the federal rules of civil procedure.
In Northern District of Georgia, the judges tend to prefer notice of objection to
Okay.
affidavit. So it's not a motion to strike, it's notice of objection to the affidavit of so-and-so.
I think the practice is you call the judge's clerk. And you explain what you want to do and find out how that judge wants to deal with the issue. Because I have filed motions to disregard motions to strike on that same argument, that they're not recognized by the rules and it's simply a way to extend the page limit of the brief.
Okay, so Randy, this would be more or less like an on-paper evidentiary objection.
Right.
Is that right?
Right.
So the general idea there, if you're the debtor, defendant, what you want to do is, especially, it may be that you're totally liable on these notes, but it may be that if, under the usury calculations, that you would end up owing a whole lot less if the notes were actually proved to be usurious. And you also might want not to have a judgment against you soon, so you don't want the plaintiff to get summary judgment. You would try to eliminate from the record things that the plaintiff had to prove in order to establish their motion for summary judgment. Now, when must a movant for summary judgment actually submit the evidence to support the motion for summary judgment?
With the motion.
With the motion. And so they can't come back, at least they're not supposed to come back later after they move for summary judgment and say, oh, here's another affidavit to support my motion for summary judgment. It's supposed to be a cohesive package that contains all that is necessary for the movement to move for summary judgment on the claims that they are moving for summary judgment on.
To what extent can you bring new affidavits in a reply brief if you're responding to arguments that the other side has made in their responsive brief?
My belief is that under the rules, you're not supposed to submit any additional evidence as the movement in response or reply to the response of the non-moving party. Does it happen? Yes. Might the court consider it? Possibly. But you're basically, as the movement, you're supposed to eliminate the arguments that the opposing party might make as part of your motion.
Well, I had a situation where I filed a motion for summary judgment with affidavits. The other side came back and they said, they essentially mischaracterized what my client had said in an email because they completely misconstrued it. So in the reply brief, we submitted an affidavit of the client that simply explained how they had misconstrued that particular email.
I think the case law says that as long as you're responding to something that could not reasonably have been anticipated,
Right.
or words to that effect,
Right.
then you're entitled to deal with it by a supplemental affidavit. But the idea is you're supposed to reasonably anticipate arguments that are going to be made in opposition to your motion, and as you said, Henry, deal with them on the front end.
Which I guess in federal court under Mickey's law, do it within the page limits that you have.
Right, or ask for an extension of the page limit.
Or you should always call the judge's clerk
Yeah.
and see how that particular judge would like you to handle it. I filed affidavits in reply briefs, but be ready for then a server reply brief from the other side.
That's right.
Right.
You're assuming that you can file a reply brief in state court.
Yeah.
No, that's state court, federal court.
Okay, but I mean, in state court, people do it as a matter of course. The rules don't contemplate a reply brief.
Right, right.
And the judges don't contemplate giving summary judgment either of it.
So going back to our hypothetical, there's one thing missing if the plaintiff creditors want to get summary judgment in an amount of money against the debtor. What's missing from what we discussed as far as a factual presentation up to this point?
Proof of damages?
Proof of damages. All right, so we've got payments all along coming from this debtor, taken in by a single person and then applied to accounts on behalf of the creditors. Some of those payments may be covering partially, a usurious note. Some of them might, let's assume for the moment, the creditor with the note that can be made non-usurious by the showing of the security deed has also been receiving payments. What must the plaintiff show and how must they show it in order to ultimately nail down how much each of the plaintiffs is entitled to in summary judgment? Let's start first with the $3,000 obvious usurious note payments. What must the plaintiff show?
Well, you're going to have an affidavit with somebody who's got personal knowledge, who testifies as to the loan history. And then you would want to need to attach business records for the bank showing the amount due. There's a case law saying you can't just have an affidavit saying there's $2,000 due. You have to have some sort of business record to show it. And depending on how complicated the loan setup is, you may even have to have a transaction history attached to it.
Okay, so yes, so one, somebody with personal knowledge, if they're available, has to say, this money came in, we split it up this way between the two notes when it came in. From each payment, we took this amount and applied it to this note, and took that amount and applied it to that note, right? That's all, and then they have to have, if they have personal knowledge, then I'm not positive you have to show the business records as to how it was applied. But for sure, if the person does not have personal knowledge, as part of the affidavits presented to the court, the actual business records of the creditors have to be made available and attached to the affidavit. We've got a brand new case y'all all ought to have in your arsenal. It's Brown versus Seaboard Construction Company, decided September 25th, 2012. Today's October 19th, 2012. Pretty current. And it expressly holds that when you're relying upon business records to establish something, it says because the business records referred to and relied upon by Swan, one of the parties, were not attached to his affidavits, the affidavit cannot be used to support Seaboard's motion for summary judgment. So the Georgia courts at this point in time are insistent upon having any backup business records that one says they reviewed in order to reach a conclusion actually submitted with their affidavits to the court. In another pretty recent case from March 2012, Patterson versus Bennett Street Properties, 2012 Georgia Appeals Lexus 299. I don't actually have the Court of Appeals site. It was very similar. It was a suit against a guarantor on his liability under leases, and the court held that the business records that were used by the person who tried to figure out how much was owed by the guarantor had to all be available to the court in order to support the testimony of the person who said that she had looked at the business records and denied summary judgment. Well, actually held that that the case ought to be reversed because there was no evidence that the business records were available to the court when this person gave this conclusory testimony based on business records that weren't in court. So you have to sort of drill all the way down in your evidence and figure out, if you're moving for summary judgment, you have to present evidence that will be admissible and useful at court in order to establish your entitlement to judgment, which may mean addressing evidence rules, not just civil procedure rules. So the general idea is summary judgment is not supposed to just be granted willy-nilly by judges because they want to get rid of a case. It's supposed to be a formal undertaking where the parties are truly entitled to the judgment that's obtained by them, because what's it eliminating in most cases?
Wow.
A trial by what?
Jury.
It's eliminating a trial by jury in many, many cases, and so that's a fairly protected right under the Georgia Constitution and the federal Constitution and many different types of causes of action. So summary judgment is not likely to be granted. Okay, so in our example,
Can I ask a question? I just want to go back to the motion to strike for a second. And I guess I'm assuming the answer will be, it depends. But in a situation where you want to file something like a motion to strike and it's not spoken to in the federal rules or whatever court you're in, is it usually the better approach to file it anyway, to call the clerk, or to, where the rules are silent, you be silent and don't file it?
my practice is do something. I mean, if you think there's a problem with the record, obviously try to figure out the right way to do it. And just because the clerk says this is the right way to do it doesn't mean that's the right way. I would do it at least the way the clerk says the judge likes it, maybe the other way too, if you know that's right and the clerk's telling you something wrong. But I don't think any court should be offended by a party advocating, for instance, the exclusion of non-admissible evidence. And so I think it ought to be done in some manner, depending on, if you're under the Civil Practice Act and the Georgia Rules of Evidence, figure out some way to bring it to the attention of the judge.
Yeah, most of the time, I see affidavits where you'll have somebody saying, and I do employment law, that I heard from somebody else that the supervisor said he doesn't like black people. So you've got at least a single, probably double hearsay problem. You can't let that stand. I mean, you've got to object to it. Rule 56 says that it's got to be admissible evidence, so or evidence that you can introduce at trial. And so that's where most of the judges, in my experience, will take a notice of objection rather than a motion to strike, because it's objectionable evidence. And now you can't file a notice of objection and re-argue your whole case. You point out in a specific document that I would call notice of objection to affidavit of John Jones, and then point out to the judge, but check with the clerk. In my experience, that's what the courts, federal courts, would prefer.
And that affidavit could even be associated, that objection could be associated with a specific paragraph in the affidavit.
Right, and that's what you do. You go right to that paragraph and show that it's inadmissible for one reason or another.
Okay, so as the moving party, you want to anticipate all those objections the defendant or non-moving party might make during and so while you're getting your discovery, you need to listen very carefully to the answers and depositions. Circle back around if the person has given a nebulous answer, so they can't come back and say, well, there are two meanings by what I said in that deposition response, and the other one applies, not the one you're saying. Now, can a non-moving party file an affidavit successfully saying, well, what I said in my deposition was wrong, what's really right is this? Can they do that in Georgia and defeat summary judgment if it's a material fact that would be caused to be in dispute by reason of their affidavit?
Can you argue self-serving statements?
That's the prophecy rule, right?
That's the rule in the prophecy case, which we talked about this earlier in an earlier Quillian's kernels, but you cannot, if you've given an answer in a deposition, you're not supposed to be allowed by the court to come back later on with an affidavit, which of course the other side has no ability to cross-examine, and say everything I said, what I said in my deposition is wrong, this is right, therefore I win. And there's a case, I don't know the full site of it right here, but it's prophecy is one of the named parties. It's not a theory, it's the actual name of a party. And it basically says you can't contradict deposition testimony with your own self-serving affidavit.
In federal court, the case is Van T. Junkins.
How can you spell that out, please?
V-A-N-T period Junkins, J-U-N-K-I-N-S. It's a leading case from about 20 years ago. But the way you get around that, if you're facing a Van T. Junkins motion, is if you can show that there wasn't a direct question on the point, or that the response is subject to multiple interpretations, then you argue to the judge that I'm not really contradicting it, I'm just clarifying it. So if the question's something like, was the light red when you went through it, and you say yes in your deposition, and you say no in your affidavit, that ain't gonna work.
Unless you're talking about a different light.
Yeah. Yeah. But if it's something that you can fudge around, that's why it's important that you have very pointed questions in your deposition and get those answers to keep somebody from fudging them on an affidavit.
That's right. Once you get the answer you like, you might want to circle back around and absolute pin it down with a perfect question and demand the answer so that there's not going to be an ambiguity when you move for summary judgment.
You want
Okay.
the site for the prophecy case?
Yes, please cite the prophecy case. Our fact checker has.
Checker par excellence.
Seth Trimble, 256 Georgia 27, 343 SE 2nd, 680. It's a 1986 case.
Okay, very good. Now sample of that case had a client that got sued by a woman claiming she was his common law wife, but it was that her actions were actually as a defense to a claim that she was embezzling from their co-owned company. But her defense was, well, I'm married to him, so I can't embezzle from my husband. But she had given a deposition testimony in a different case during the exact same period of time where she said, I'm not married to him and I never will marry him. And the court accepted the deposition from the other case in our case in order to reverse a denial of summary judgment to my client on the marriage issue, which in turn opened the claim that she was inappropriately taking money out of the company and you know, basically in violation of
That was a
fiduciary
match made
duties.
in heaven, wasn't it?
Yes, it was.
And this may be a topic beyond our current topic, but, and you may have dealt with this already. If you did, I apologize. But the extent to which you can take an errata sheet after a deposition and change your testimony in the errata sheet.
I think we did lightly touch on that, but does anybody know what an errata sheet is?
It's where the deponent makes corrections or revisions to the testimony given in his transcript.
Okay, and how long under the Georgia Civil Practice Act do they have to do that after getting the transcript?
30 days.
And how do they have to do that? I mean, what is the mechanism?
Written affidavit or sworn correction.
You write what line it is, what the change you want to be made, you explain why the change needs to be made, and you have to sign and have it notarized.
Okay, so the key here is you have to do it timely after getting the transcript if you're the deponent. Generally, you need to discuss in the deposition whether you're reserving your right to read and sign the deposition. And then you have to give an explanation that has to have some logic to it as to why you're making the change to the testimony. If you don't have that description as to why, I think if you got into summary judgment and if a judge was being very particular, the judge may refuse to accept the changed testimony as a basis for defeating summary judgment. It's hard to say whether how that would come out. Has anybody ever had that circumstance where the errata sheet became the topic of whether summary judgment was appropriate or not?
Not exactly, but I've had plenty of fights with errata sheets with opposing counsel. There, in federal court, there are some cases where attorney's fees have been assessed against the attorney who corrected the deposition multiple times, like hundreds of times. It just really went in and redid the deposition more to their liking. But in my practice, I believe that you have a right to make changes where there's a good reason for it, whether it's 1 or 2 or 10 or 15, but the more you make, the less likely it is a judge is going to allow those changes to stand up, especially if there are questions like, was the light red? Yes, in my deposition, no in the errata. You better have a pretty good reason for changing your testimony, like I didn't hear the question or something.
I never dealt with this, but isn't the evidentiary rule that you can't erase your deposition testimony? It's there, and it can be used against you, no matter what change you make in the errata sheet. I think that's the rule, isn't it?
I think that is the rule. So you'd have to give the same explanation on the stand if you're being cross-examined as to why it's different. But I've definitely seen circumstances where a witness gets into a mode probably because of not very good questioning by the asking attorney, and they're in a whole different time frame from what the attorney has now switched to talking about. And that causes all sorts of chaos because they answer all these questions like I never saw that, etc. When in fact they're thinking as their childhood instead of their adulthood or something.
If it's something critical, you're not getting summary judgment in that situation one way or the other. It's going to be a jury question.
Right. Can you, let's assume for the moment you move for summary judgment and it's denied because, let's say, the creditor in this circumstance fails, or the creditors fail to attach business records to their affidavit stating how the money was allocated, or showing how the money was allocated when it came into their single person loan servicer. And so the judge says, well, I think there's questions of fact here as to how the money was applied, therefore I'm denying summary judgment. And the judge at the same time doesn't make any ruling on whether there's liability or not, because it's just a one-line order saying there are genuine issues of material fact, I deny summary judgment. Can the creditors come back and remove for summary judgment?
Sure.
How many times can you remove for summary judgment?
I don't think there's a specific limit.
7 times 7.
You can remove for summary judgment. Sometimes there are obviously limitations on that. For instance, the Superior Court judges all around here in the metro area seem to have been very keen on doing scheduling orders in recent history. And certainly district court judges do, and there's all sorts of federal rules that limit the time for filing of this, that, and the other. And so you would have to do all your moving within the time allowed by the individual court and the individual case. Now, other than the individual rule by an individual judge, what's your limit on your ability to move for summary judgment?
Soon enough not to delay trial.
Okay, soon enough not to delay trial, which means it has to be at least how far back from trial?
30 days, because they have 30 days to respond, and there's no reply brief allowed, or
Is it 30 days or is it 33 days?
if you mail it, it's 33 days.
Okay, so if you got trial, you sure as heck better hand serve your motion for summary judgment if you're 30 days prior to trial. Or alternatively, if for some reason the judge sets a hearing date saying all summary judgment motions shall be heard on this day, you have to move at least 30 or 33 days before that hearing. Now, is that a good idea to wait until that last minute?
You,
Now, the judge is likely to just say, don't have enough time to deal with it, not going to deal with it. Let's see, I had something along those. Oh yeah, so you can't delay trial by moving for summary judgment. Let's assume that you are coming up on trial and you don't think the judge is actually going to get around to hearing your summary judgment motion, even though you're 45 days away from trial. Should you file one anyway if you think you can win?
Yes.
Yes.
Yes, and what would be a good reason to do that, even if you think the judge will never actually get around to ruling on it?
You can plant the seed in the judge's mind about these issues. They say are not in dispute, and you can, and the legal issues, and you can set yourself up for a motion for
Encourage
judgment as a matter of law.
Yeah.
That's right. That's right. You can encourage the judge to learn about the case in advance of trial, learn about the legal issues, gives you an opportunity to present the legal issues at a time when the judge isn't right in the middle of trial trying to decide too many things at once. All right, now, this is a good one. If you're
You
moving,
can appeal it to the Court of Appeals, can't you? It's turned down.
all right, if your motion for summary judgment is denied, we're getting way down the road here, but if your motion for summary judgment is denied,
Not the-
can you appeal it if you're the moving party?
Not as a matter of right.
Not as a matter of right, you'd have to get a certificate from the trial judge allowing it to be appealed, right?
So if you have a really tough issue that the judge doesn't want to handle, and you think that the Court of Appeals is going to have to handle it anyway, and you have a long trial that's going to depend in part on what the law is, then that would be a circumstance where you'd ask for a certificate in front of the appeal.
But you can't get a certificate if the judge doesn't rule.
That's right. If the judge doesn't rule, you can't get a certificate. Now, in this particular instance, let's say you realize that you failed to get some discovery during the discovery period, and there's something you'd really like to know before trial. Can you use summary judgment as a means of trying to flush out evidence from the other side? Yeah, so if you know that the other side has to cough up their position on a particular point and or some document that you failed to get, and you're not able to get it during discovery, but you want to know what it is before you get up to start your case and make your opening statement to the jury, you can move for summary judgment in hopes that the defendant will be forced, or the responding party will be forced to cough up that information in order to defeat the summary judgment motion. So that would be a circumstance where you could even argue in good faith, based on what I know, I win. And it's only because the defendant came up with this document, which I didn't know for sure existed, that I've now lost summary judgment, but at least you have the document. Now, what about this? As the movement for summary judgment, are you entitled to a hearing on the motion for summary judgment?
Yes,
I think you have to request
you have to request it.
As the movement, are you entitled to a hearing?
I know the respondent, you're entitled to one if you move forward.
All right, definitely as a respondent under the Uniform Superior Court rules, you're entitled to a hearing, and you have to make that request for a hearing when?
Within 5 days of response?
So you think it's within 5 days? Are you sure about that?
I'm pretty sure it's within 5 days after your date for response.
Okay.
I think.
I didn't actually check that coming in here, but when in doubt,
Check the rule.
you read the rules. So if you're the respondent, why would you want to have a hearing on the motion for summary judgment?
Present your evidence that you claim is in dispute directly to the court.
Your evidence.
Wave your arms on a piece of paper.
That's,
You gotta say that.
this is a classic reason for having a hearing. You can bring the big pile into the judge and say, if there's this much written about it, there's no way there are no genuine issues of material fact. But yes, it gives you an opportunity to make sure that the court knows, looking the judge directly in the eyes, about the evidence that you claim gives rise to a genuine issue of material fact. And then also, if there's some case law that seems to be, could go either way, but you know that you can walk the court through the very complicated facts of a case that make all the difference, that make what the other side has stated as a general proposition not true at all in your case, then you would want to, it gives you some certainty. And also, if you bring your client to a motion for summary judgment hearing, are there any advantages to that?
Yeah, introduced to the court. This is my poor Mr. Smith who's gonna have his rights taken away from him if you grant this motion.
Well, that's true.
But typically you don't get testimony.
Right.
Well, you wouldn't get any testimony, but what does the client get to see if they come to court on a motion for summary
How
judgment?
bad a lawyer you are.
They get to see how good a lawyer you are. That's good.
In Randy's case.
And they get to see the judge actually, hopefully, grappling with the case And if the judge doesn't grapple with the case, then you can tell the client, well, this is a totally unreliable judge, maybe we need to think about something else, some other way of addressing this. And to me, it often brings the client to a much more realistic view of what they're dealing with in the case, particularly if they're really close issues of law, or the client has made some bungling mistake during the course of doing their business, and they don't want to acknowledge that that bungling mistake really has anything to do with their ability to recover or not. There are a lot of advantages to having a client there. It gives them a little bit more realistic view of what you're dealing with on summary judgment.
And the reverse of what I said is true. I've always found that it's good to have a client there, because if things go bad and they see how hard you've worked and how well you've done, they're not going to blame it on you as much as if you just send them a letter and say, oh, we lost. Sorry about that. You know?
Right.
If they see that you, and the same with, trying a case. If the general counsel from your client wants to come and attend, I always encourage that, because then they can see me in action. And if they don't like me, they get another lawyer. But if you're a pretty good lawyer, you're going to be viewed more highly by your client than you should.
If you're going to have your client there, what do you want to be? What do you want to do?
Prepared.
Be prepared, and you want to look sharp, be sharp, right? Don't go in with a rumpled suit and fumbling through a whole bunch of papers with no organization, apologizing to the judge and the jury at every turn, because then they will get mad at you. Okay, so can a judge take a motion for summary judgment that's been poorly presented and more or less redo it for the moving party to make it workable as a summary judgment motion?
As long as the record supports it, it's got, what has to be there has to be in the record. It's not going to get affirmed on appeal.
Okay, does it have to be specifically pointed out by the moving party in the record, or does it just have to be there somewhere?
It's got to be there somewhere.
Okay, yes, apparently, although I highly don't like it, apparently a judge can, under Rule 56D, look at what's there and more or less work the parties and work the file themselves to enter a partial motion, a motion on partial summary judgment in order, dealing with certain aspects of the case, trying to narrow the case. The other thing I found in summary judgment hearings, and something to be aware of, is the court will try to get you as the advocate to agree to things that the other side's never put into the record. Now, if the judge turns to you and says, let's say you're representing the debtor here, and the other side never put in their motion anything about the debtor failing to make payments, do you think the judge appropriately can ask the lawyer representing the debtor, well, didn't he on this date fail to make payments?
The judge can ask anything.
All right, do you have to answer the question to the court?
I think you better.
Well, I mean, I've taken the position, we're here on summary judgment, Your Honor. I'm not here to give up facts for this case. I mean, it's the plaintiff's burden on summary judgment. They're trying to
That's a fair
get...
response, but yeah, I mean, I don't think you have to necessarily concede anything that isn't in evidence.
Right.
If you can say, that's disputed. It's not been proven. We're here, part of the reason why we contest summary judgment.
Now,
Evidence in the record.
Yeah.
what if it's not disputed at all? It's just only disputed as to whether the plaintiff has established it in their motion. Is it wrong to say, Your Honor, I don't have to answer that question? I'm not a witness. I'm just a law advocate.
Well, yeah, I think you have to be careful, because if you push that too hard, you lose credibility with the court, which is something you definitely don't want to do. So, if the judge presses and says, all right, really, are you seriously contesting that your guy hasn't, he's in default, that he hasn't made payments? Are you going to present evidence that he's made all the payments? Point blank question. I think you're on real thin ice if you tell him you're going to contest that, but you know full well you can't present any evidence.
Well, plus he can ask for an extension to correct the record too. And you've just embarrassed yourself in front of the court. So, for example, in your debt thing, if the plaintiff doesn't say that that's the defendant's signature, the debtor's signature, and that's not in the record, but we all know it is, and the judge asks you, well, isn't that the debtor's ask the counsel, the debtor's counsel, isn't that your client's signature? And you say, well, Your Honor, I'm not gonna tell you because it's not in the record.
I think what I would do there is say, if they want to use that as part of their motion for summary judgment, they can file another motion for summary judgment. But on this one, remember we're talking about the guy's gonna have a judgment against him today if you make this admission. And then you're not gonna get paid because they're gonna take all the money out of his bank account and put it into the plaintiff's instead of into yours.
Maybe.
Yet it might be 2 years before the guy otherwise has to pay on this debt.
True, but what I would say, representing the other side, say, Your Honor, it's not contested. I filed the motion. I didn't think that would even be an issue, but if it is an issue, I can have an affidavit here by this afternoon saying that is his signature, and we'll refile the motion and move forward.
Right, so, and then it might be another 6 months or 8 months before the judge gets around to hearing that motion.
Right?
Now, the other question is it a material fact? The judge may be able to say,
Could be.
well, I don't even need to know that it's a signature. We've all, the answer said he executed notes. So, all right, that's enough for us to thank you for this very active discussion. Come back next month for Quillian's Kernels.